Okay. I thought they went home. I was in bed. I was almost asleep. And then I got a notification.
Or elsewhere. Bless you. It will be up to you to decide whether to preserve your privacy as a juror or not.
Come on.
Again, on behalf of myself and
Hey,
the entire judges of the 12th Circuit, thank you very much for your time and your
did
attention
I
during
miss
this
it?
trial. I now discharge you as jurors in this case and release you from any further obligations in
Well,
this matter.
shoot.
You're free to go. Make sure you pick up your electronic device.
My computer's been acting funny all day. I'm starting to think it's my
Whatever your
computer.
personal feelings are about this jury's verdict, I ask you to remember that these jurors were randomly selected from our community. They were thoroughly questioned by the court and lawyers for both sides. And they were selected from the larger group to hear this case because of their demonstrated ability to be fair and impartial. I've paid close attention to this jury, and they have been attentive, observant, and focused throughout the trial. No matter how much you agree or disagree with the verdict, there are to be no outbursts of emotion. Our judicial system, in fact our entire society, has relied on jurors to help resolve disputes for over 200 years. Their verdict needs to be respected even if you don't understand it or don't agree with it. You ready to bring in the jury? Yes, sir. All right, bring them in.
I know. And I have a feeling that they just compromised because they wanted to go home and didn't want to come back tomorrow. Now I understand why they didn't want lesser included. I always thought lesser included were good because then if they thought they were guilty, then they didn't have a lesser one to fall back on. You know, like if there was some doubt, then they would say, oh, well, then no, she's not guilty, and then there would not be a lesser one to fall back on. I don't even know if I'm making sense right now. It's
All
too
right.
late. I'm
Members of the
old.
jury, I understand
I
you
go
have
to
a
bed
verdict
early
and
now.
we have a foreperson. Ma'am, has the jury reached a verdict?
Yes, we have.
Is the verdict unanimous?
Yes, it is.
Would you please hand the verdict form to the deputy? I need to check it, make sure it's in proper form. Thank you. All right, the verdict appears to be in proper form. Madam Clerk, would you please publish the verdict?
In the Circuit Court of the 12th Judicial Circuit in and for Manatee County, Florida, the State of Florida versus Ashley Benefield, case number 2020 CF 3014. Verdict. We, the jury, finds as follows as to the defendant in this case. The defendant is guilty of manslaughter, a lesser included offense. Did Ashley Benefield actually carry a firearm? Yes. Did Ashley Benefield discharge a firearm? Yes. Did Ashley Benefield, as a result of discharging a firearm, cause death to Douglas Benefield? Yes. So say we all this 30th day of July, 2024, at Bradenton, Manatee County, Florida. Cheryl Forkerson.
Would either side like the jury polled? State?
No.
Defense?
Yes, sir.
Members of the jury, you're now going to be polled. The clerk is going to ask each of you individually if this is your verdict and the verdict of the jury as a whole. Madam Clerk?
Juror number 15, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 20, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror 21, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 29, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 33, is this your verdict as well as
What's
the
the
verdict
max?
of the jury as a whole?
Yes.
And juror number 35,
What's
is
the
this
max
your
for
verdict as well
manslaughter?
as the verdict of the jury as a whole?
Yes.
Thank you. Members of the jury, I want to thank you for your time and consideration in this case. I know that many of you have missed important work obligations and family obligations and other engagements that you had planned, as well as time with your families. But I want to thank you for being willing to give us your time and your attention and being observant to this entire trial and serving as jurors and doing your civic duty. I have paperwork that we're going to give you that will reflect your service as a juror, as well as a piece of paper from the clerk's office documenting that each of you has been here for these number of days if you need it for work purposes. If you need some sort of other paperwork for work or anything like that, contact my judicial assistant and we'll be able to get that for you. I also want to advise you of some very special privileges that all jurors enjoy. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak with anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. Bless you. It will be up to you to decide whether to preserve your privacy as a juror or not. Again, on behalf of myself, the entire judges of the 12th Circuit, thank you very much for your time and your attention during this trial. I now discharge you as jurors in this case and release you from any further obligations in this matter. You're free to go. Make sure you pick up your electronic devices, and please make sure that your notes stay with the deputy. They're going to be returned to me. They will be destroyed. No one will ever read your notes. Thank you.
I almost feel like at one point she may have been manipulative. I still say at the moment she shot that gun, she was in fear. And I think that might be where the problem with finding her not guilty was.
State.
Judge, I would ask you to remand the defendant at this point. I believe she has a right to a PSI for sentencing, so I'm not sure if she would waive that or proceed with that.
Do you want to PSI?
I think we'd prefer to have the PSI.
I'll sign an order tonight for that. It's a late
I could have
evening.
sworn
My
they were going
judicial
home.
assistant will reach out to both of you tomorrow to begin coordinating a hearing, sentencing hearing. You could let her know how much time you need. Right now, the pre-sentence investigations are running a month to 6 weeks, so it'll certainly, the time for sentencing will be outside of that, but then you can let me know how much time you'll need.
Let me direct myself, Your Honor, to post-trial release if I can.
Yes, sir.
Under Youngston, I know that the Younghans, rather, I know that the court is familiar with the standard. They stated in no uncertain terms, but if taken in good faith on grounds not frivolous but fairly debatable in view of the decisions of the Supreme Court, then the petitioner should be admitted to bail. And they set out for the trial court 3 factors. The first, with respect to the appeal not being frivolous, I think by the court's own acknowledgement at 2 different points in the trial, the court noted that we were dealing with novel issues that the court had not seen before. I think we certainly have good and sufficient grounds to appeal in good faith. The factors, according to Younghans, Your Honor, is the habits of the individual as respect for the law. Ms. Benfield has no prior history of criminal activity, as the court knows. Her local attachments to the community by way of family ties, business, or investments. She lives here in Bradenton, has lived here for a while. Her mother resides here. Her child resides here. The severity of the punishment imposed for the offense, that is substantial. There's no denying it. And any other circumstance relevant to the question of whether the person would be tempted to remove herself from the jurisdiction of the court. Ms. Benfield, on every single occasion over the course of the life of this case, has appeared when requested. She has never once failed to meet any obligation pursuant to the bond that she's on. As a result, we ask that the court entertain setting a post-trial bond. The only other thing that the court noted in the Younghans decision was that it's axiomatic that the exercise of judicial discretion should never be arbitrary, capricious, or unreasonable, and where the discretion is exercised in favor of denying to a person a basic and fundamental right, the reasons for doing so should be sound and they should be clearly stated. So pursuant to Rule 3.691, post-trial release, Your Honor,
You want me to open the door?
we ask that the court admit Ms. Benfield to bond, continue her on the same bond, in fact, and if the court is not inclined to do so, we ask that Your Honor stay the decision so that we can appeal directly to the 2nd District. As the court knows, it's an accelerated docket because of the nature of the motion, that is to say, the bond.
Thank you. State, did you want to be heard?
Judge, I object to any bond at this point. The potential
Yeah, of
sentence is
course you
30 years. While this defendant may have appeared at every court hearing, she was not convicted of the charge at the time. She has much more at stake at this point, being convicted of this crime, and I would ask you to deny the bond.
Any rebuttal?
No, sir.
Ms. Benfield, the jury, having found you guilty of manslaughter with a firearm, are going to remand you to the custody of the Manatee County Sheriff. We're going to revoke your bonds where you'll be held pending sentencing.
Man, you know she's tired too. She's been there all day.
All right, the court will stand in recess until we get a sentencing hearing set up.
Thank you, Your Honor.
I trust Your Honor will issue a written order on the bond.
The bond?
Yes.
Yes.
Yeah, I agree. This sucks.
If it's required, I certainly will.
Thank you, Your Honor. Thank you, Madam Clerk. Thanks.
Thank you.
You know, it's definitely you have to live your life nowadays like the whole world is watching. Because if she hadn't done some of the things that she did, I'm not victim blaming, I'm just saying, if she hadn't done some of the things that she did, they might not have found her guilty. Man, that's horrible. I didn't realize that the max for manslaughter was 30 years. I thought manslaughter, well, I guess I'm thinking about involuntary manslaughter. So I guess voluntary manslaughter yeah, I guess that's appropriate. Because involuntary manslaughter is like 18 months. That is so sad. And her daughter's going to have to go visit her in jail for most of her life. Hopefully, she'll get out early for good behavior or something. I don't see her putting up a fuss in prison. Man. Oh, well. Thank you guys. And thank you, Lisa Harvey, for subscribing. And I will see you guys in the next one. And sometime this week I will have a new true crime video coming out, so look for that. This is true. She could be the one not alive right now. Okay, guys. Sweet dreams, or enjoy the rest of your day, whichever it is. Bye, y'all. Oh, yeah. Yeah. He was gonna be just fine.